a reply brief to the opposition brief of Duncan, which is our lawsuit challenging the magazine ban that we have here in California, has been filed. There's a lot leading up and a lot going on with Supreme Court, so we're going to give this one a little bit of attention. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are back on Duncan as more briefs end up getting submitted to SCOTUS. First we had the original petition, then we had the opposition brief, and now we have a reply brief to that, just continuing to make the case for SCOTUS to take Duncan on the ban on standard capacity magazines here in the state of California. To walk us through that today, we have brought back CRPA's president. He is also founder of Michel and Associates. That is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thank you for having me.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to the videos. Really helps the channel, really helps get this information as far and wide as it possibly can. We've got some huge decisions that the Supreme Court of the United States is going to have to make on Second Amendment litigation coming up through the end of this year and into next year. We need to make that push. So if you can, please like, share, and subscribe. It really helps get this information out as far and wide as possible. So, Chuck, I guess I'll give a little summary of what I read from the brief, and then I want to read part of this for everybody and then kind of talk about it a little bit. If you guys remember, our initial petition to SCOTUS went through, and then the state offered their opposition to that, basically saying SCOTUS shouldn't be granting certiorari for the Duncan case for a couple of reasons that they laid out, but they primarily said that this wasn't really an issue. There were no circuit splits on this. There wasn't any reason that SCOTUS actually needed to take it. And in our response, kind of the three primary arguments that are made in this position was, first, that SCOTUS should resolve whether the state can ban commonly owned firearms. Second, that SCOTUS should resolve whether the state can compel law-abiding citizens to dispossess themselves of lawfully acquired property without compensation. And then third, that Duncan is an excellent vehicle to do this. And I guess to start, because it's kind of the primary opposition to the opposition brief, I wanted to focus on that third question first. So Jacob, if you could pull this up, it's from our reply brief. It's question 3, and it reads like this. Respondent does not deny the importance that of the question presented. Instead, he argues the court should deny certiorari because it has denied magazine-related petitions in the past. But this court was wary of taking those cases because they arose in an interlocutory posture, and even then, there were 3 votes for certiorari. Unlike those cases, this case has reached final judgment after nearly a decade of litigation and multiple rounds of en banc proceedings. There is no longer any reason to wait, especially given the consequences that denying certiorari would have for the countless Californians who, like Petitioner Lovett, will become criminals overnight if the Ninth Circuit's mandate issues. Respondents try to run away from that reality, but he ultimately ends up blaming the victims of California's legislative overreach for lawfully purchasing arms that he thinks they should not have. Finally, the court's recent grant of certiorari in Wolford v. Lopez does not counsel against certiorari here. The case about the default rules for constitutional rights on private property has little to do with this one, apart from the fact that it too arises out of a circuit-splitting decision from the Ninth Circuit. And even if Wolford or U.S. v. Himani might have some bearing on this case, that at most would be a reason to hold this petition, not to deny it. But the far better course would be to grant certiorari and make clear once and for all that the Second Amendment protects the right to keep and bear arms, including their constituent components that are commonly used by law-abiding citizens for lawful purposes. And I guess before we get into the more technical questions here, Chuck, I'm just sort of curious how this normally plays and what your opinion is. This is kind of like bickering. Both of these statements can't be true. There either is a circuit split or there is not. The state is trying to bring up this line of argumentation that just sort of seems false, and SCOTUS would know that, right? I'm just sort of curious, with this back and forth going on, does that normally compel SCOTUS to want to take it even more? Does it have any bearing on whether or not they take this?
Yeah, when there's a circuit split, those are the most commonly granted cert petitions. When people ask for review and there is a circuit split on an issue, that's something between two circuit courts of appeal. That's something the Supreme Court is more inclined to weigh in on to resolve the circuit split of opinion. In this case, they're kind of splitting hairs. I mean, there's no circuit split on whether or not a magazine ban is unconstitutional or not. But there are multiple circuit splits on sub issues like whether or not magazines are arms or other things, suppressors or bump stocks or other things are part of the protected arms in the express language of the Second Amendment, and what the right methodology is. So there's in determining whether or not there's a relevant historical analog. So there's multiple circuit splits on the approach. What is or what is not a covered arm? What is or is not a sufficient analog law that would justify a modern day law? There's multiple circuit splits on those issues. So it's artful dodging on their part to say there's no circuit split. There's multiple circuit splits on issues that the Supreme Court really needs to resolve. But it's not just applicable to a hardware case, a magazine case, or for that matter, an AR semi-auto case. It applies to also sensitive places, which is the Walbert case, or sensitive or banned people. Remember, most of these cases deal with either people that the state wants to say are bad and so they can't own guns, or places that the state says are sensitive so they can ban guns there entirely, or type of hardware that they say is bad so they can ban the possession of the hardware entirely.
Gotcha. So, and I was going to say that sort of makes sense. So, while there might not be a circuit split on a magazine ban itself, when the argument that you have to affirm a magazine ban is that a magazine is not an arm, and then you have a circuit split on whether or not a magazine is an arm or not, that would definitely constitute as a circuit split when you reference that to uphold the magazine ban here in California. And I guess going into some of the more technical arguments here, one of the arguments that we have on resolving, whether the state can ban commonly owned arms, there were two things that were provided in that section in the brief. The first one was that Duncan deepened this the three circuit splits that we have here, and that Duncan can't be reconciled with the current precedent that SCOTUS had. Can you walk us through these two arguments? What exactly do we mean when we say Duncan can't be reconciled with the current precedent that SCOTUS has?
The methodology and what is not an arm. The Supreme Court has said in Bruen and Heller, never mind even the common use test. The common use test is the flip side. The Supreme Court has said that there are historical laws that it seems like the founders' focus was banning unusually dangerous and unusual. They said dangerous and unusual. Obviously, every gun is somewhat dangerous in the wrong hands, especially. But they're talking about unusually dangerous, which to me means non-discriminatory, like a grenade. It's not a targeted, aimed at a specific target. Or unusual meaning it's some kind of exotic firearm that's camouflage briefcase gun or something that they're saying is unusual. But the state is trying to claim that it doesn't have to be dangerous and unusual. It can just be dangerous, and that it doesn't matter if it's unusual. Remember the real test here, it's not just because it's in common use, that means it can't be both dangerous and unusual. It's not unusual if it's commonly possessed. But those aren't the only guns or arms that are protected. If you have someone you may have a high precision rifle for marksmanship that almost no one owns, but that's going to be protected too, because marksmanship is part of the conduct that is protected by the Second Amendment. The right to keep and bear arms doesn't mean much if you can't be a good marksman. So the state just goes out of its way to twist all these concepts and hope that they get a chance to keep pursuing them and make them binding law. And this is what the Supreme Court really needs to put a stop to.
Well, I keep harping on this part too, and with every single time we address this issue, I am trying to make sure to mention it. I want to ask you about it one more time here, because there are lots of Californians who have magazines that can hold more than 10 rounds right now. Prop 63 has long been done and instituted. The litigation's been going on for a long time. Why even raise the question of whether citizens are going to be compelled to dispossess themselves of these items if the ban were put in place?
Well, because if the state has to pay people every time it bans something and takes it away from them, that's going to discourage the state from passing the laws where it costs them money. So the takings claim is very important. It's not a fundamental Second Amendment claim or argument, but states should not be able to take away any kind of property by simply declaring that they're, illegal and not pay it when they've been legal for decades, centuries, and without incident. And people have bought them, spent money on them. The state's arguing that, well, you can sell them out of state, or you can convert a 30-round mag to a 10-round mag, or but it's still a taking. You can't have the 30-round magazine, which is not just a value doesn't just have value as a piece of property, the cost of the magazine, but it has value as a self-defense tool too. So that's all something that the state wants to take away. And if they, for some reason, we don't believe it's constitutional in the first place, but if for some reason the state did declare something that was protected by the Second Amendment or wasn't protected by the Second Amendment to be illegal, they should pay you if they're going to make you get rid of it.
Yeah, and more importantly, what my mind goes to is the fact that if you are sitting at home right now in possession of a magazine that can hold more than 10 rounds that you purchased legally, you are already benefiting from this lawsuit. I think too many times I end up talking to people, and this just kind of gets lost with this lawsuit, because what seems to be challenged right here is the ability to manufacture and sell these magazines in the state of California. But Prop 63 did more than that. They said that if you have it, you have to dispossess yourself of it. You cannot even possess these magazines. And because of the injunction that we got, I think back in 2017 or maybe it was 2019, that has carried through today, where those grandfathers' magazines could continue and be possessed by their owners throughout the course of this litigation.
And don't forget, a lot of people got these magazines during Freedom Week, which was part of the Duncan case, where for 1 week the ban was enjoined, blocked, so people could actually go out and buy the magazines. And there was a huge pent-up demand. Millions of them were sold into the state during that 1 week period when we blocked the law until the Ninth Circuit weighed in and put it back in place.
Yes, and that's what it is. Freedom Week was 2019. The injunction that we got was July 1st, 2017, right before this law went into effect. I kind of want to keep harping on that, because as this lawsuit comes to its conclusion, we need to understand that if the ban is upheld, that's going to be upheld too. So this definitely a huge reason to continue in fighting for this lawsuit, because that's like going backwards. You know what I mean? That is having to dispossess yourself of these magazines, not just being able to purchase them. So there are two sides to that coin. I guess, Chuck, as we round this out, what is there to look forward to with this case? What should we be watching for going forward?
Well, remember let me just put a finer point on that last point. So remember, with so-called assault weapons, the semi-automatic ban, they allow you to register the firearm so that you can keep it. So that's how they dodged the taking issue in some of these bigger hardware cases where the entire firearm is involved. But rather than have you register a magazine, they just said you can't possess it at all, and that's the taking. But Duncan is one of 28, I think, cases that have asked the Second Amendment cases that have asked the Supreme Court to grant cert and review. So it's by far one of the most thoroughly baked cases. It's been up and down, tried twice. All the evidence is in the record. Many of the other cases that are asking for review are not that fully developed. So Duncan stands out in that respect. But now I think there's Connecticut. There's several other states where they have the semi-auto bans that are asking for review. And again, it's It's people, places, and things. There's a bunch of prohibited people, 18 to 21-year-olds, that are petitioning the Supreme Court to get rid of laws that say 18-year-olds can't own a firearm. There's a lot of places where they're trying to say that your CCW is invalid or you can't have a firearm at all in particular places under any circumstances. And then there's things, which is magazines and hardware of various types, whether it's a suppressor or an AR or whatever it may be. But so there's a mix of those cases out of the 26 or so that the Supreme Court's being asked to review. It may be a sign that the Supreme Court wants to think about all these cases on one day. That's maybe why they postponed the Duncan conference. Every Thursday they have a conference where they consider cases and whether or not to grant review or not. They deny 99 out of 100 of those cases. And then on Monday, they issue the order. So today, there was no news on Duncan or on any of the, we're recording on Monday, or in any of the other cases. So they may be kind of grouping them to have a Second Amendment case review day, and then they'll figure out which cases they want to take. Hopefully, Duncan is one of them. But even if it isn't, or even if some of these other cases aren't formally accepted, they should hold those cases until after they issue a decision in Walford and Harmani and whatever other cases they may take, because the guidance that they're going to give the lower courts, that basically they need to slap these lower courts down and straighten out the way they're evaluating these cases. And the guidance that they give them in that regard is going to be helpful in every case, every Second Amendment case, no matter what it involves.
Yeah, and it certainly does seem like a buildup similar to when they ended up taking and coming out with the Bruen decision. A hefty task for the Supreme Court of the United States, but we are going to be following along with it every step of the way. Chuck, I know that you're a busy guy. Thank you very much for taking the time and coming on with us today.
Hey, thank you. And thank you for supporting the CRPA, everybody who's watching. It's a historic time for the Second Amendment, and the legal field is evolving quickly, relatively speaking, to the way the law evolves. So if you can support the CRPA in our efforts, we'd appreciate it, and you'll be a part of the history along with us.
Absolutely. Thank you very much once again, Chuck. And guys, if you want to continue and see content like this, please be sure to like, share, and subscribe to the channel. Really helps get the information out there. This is a big push collectively to the Supreme Court to continue and clarify this Second Amendment question. We're going to be along for the ride. We are doing our part by getting our litigation there, and we hope that you come along with us, and you can do that by liking, sharing, and subscribing. Click that notification bell so that you get notified every time we come out with a video. Thanks again, guys. We'll see you on the next one.